Good morning. My name is Madison Barnett. I'm attorney with Sutherland, Asbill, and Brennan, and I practice state and local tax law. And we're here this morning to talk about Georgia property tax, and specifically as it relates to nonprofits, exemptions they may qualify for. Before we get into the substance, I just want to cover a few housekeeping matters. This webinar is provided by Pro Bono Partnership of Atlanta, and the Pro Bono Partnership they help connect nonprofits in Georgia that need free legal advice with attorneys that are willing to help, and they do a great job. I've worked with them over the years in the past, and they're great at what they do. So thank you to them for hosting this today. And there on slide 3, there's some information as far as qualification. If you're interested in becoming a client of the Pro Bono Partnership, there's information there on slide 3 about what those requirements are. And then one last housekeeping item. This is just a general information presentation, just for information purposes. It's not specific legal advice. And so if you have an issue related to property tax, I would encourage you to consult an attorney or go through the Pro Bono Partnership. So today we're going to go through an overview of Georgia's property tax system in general, and sort of what is property tax in Georgia, how is it imposed, who are the players involved, and then specifically for nonprofits, the most important exemption from property tax is the purely public charity exemption, is what it's called in Georgia, and that's what a lot of nonprofits will qualify for. So we'll go through what the requirements for that are, what you need to be thinking about when you own property in Georgia to make sure you get that exemption. And then talk about how you apply for it, kind of the mechanics. And then at the end, we'll have some opportunity for questions and answers. And if you have any questions kind of as I'm talking here, feel free to type them in, and we'll get them answered for you. So Georgia's property tax system, there's two main property taxes in Georgia. One is on real property, and that's really kind of the land and the buildings attached to the land. That's the property tax bill you pay on your house every year. That's real property tax. And then there's also business personal property tax, and people are less familiar with that personal property tax. If you're a business in Georgia and you have personal property, it might be a computer, it might be a desk or chairs in your office. Those are subject to tax in Georgia unless you qualify for an exemption. So it's something that's something I've seen nonprofits miss in the past, is if they haven't filed personal property tax returns or applied for an exemption there. And both of these are ad valorem taxes, and all that means is that it's based on the value of the property. The tax is measured by the value of the property. And so who is involved in administering Georgia property tax? The property tax is primarily a county level tax in Georgia. The state is involved some. They set the law that governs the counties, as well as some of the general guidelines. But it's primarily a county-driven tax. So all 150 plus counties in Georgia, that they each have their own individual tax administrator, and that's done through several different divisions of the county. The Board of Tax Assessors at each county is who decides what property is subject to tax, what the value will be. That's the people you'd be dealing with when you apply for an exemption, is the Board of Tax Assessors. And then the county commissioners, they set the tax rate. The tax commissioner is a separate party from the Board of Tax Assessors that actually collects the tax. They send you the bill. And then finally, the Board of Equalization is in each county where you would appeal if you were denied an exemption. So we talked about this being an ad valorem tax. It's measured by the value of the property. And so that value that's used for tax purposes is the fair market value of the property. It's essentially, as of January 1st of the tax year, sort of, you just take a snapshot in time as of January 1st, and you say, what would this property sell for on an open market? What would someone be willing to pay for this property? That's roughly how you measure value. And so there's different ways that fair market value gets set. You can file a return for real property tax. Most people don't file returns for real property tax, and you don't have to file a return. You would only file a return if you think that the value should be changed this year. So if you think your value is overvalued, or you think you should, maybe if you think that there's going to be exemption, you would file an application for exemption, but you might file a return. You do have to file a return for personal property tax. And so that's an important thing that people will sometimes overlook. So if you have an office building, if you have an office and you have desks and computers in that office, you need to file a return every year. Generally by April 1st, it varies by county, but you need to file that return every year. And so the valuation, once your value gets set, whether you file a return or not, the Board of Tax Assessors will determine what the value they think is the right value. It has to be uniform and equally valued with other property in the area. So you could argue that your value is they're valuing your property higher than your neighbor's value, and that's a valid basis for challenging it. And you may the property tax is imposed. It's measured by fair market value, but it's imposed on assessed value. And this is one of those quirky aspects of the property tax that has been around. It's just kind of a relic of 100 years ago when they designed the property tax. You would just take 40% of the fair market value, just a flat haircut, and then you apply the tax rate to that reduced value. And there's no good reason why they do that other than to potentially confuse you about what your real property tax value is. But that's the way it's done, so you'll see that in the way that property tax is calculated. And so once the assessment process is done, you'll get a tax bill. And the tax bill is issued by the tax commissioner, and it generally comes out sometime in November of each year. And it comes, some counties let you pay in installments, but whether you appeal or not, you still have to pay your property taxes each year, unless you're exempt, obviously. And so generally the owner of the property is subject to tax on the property. And it's January 1st of the tax year that's the important date. It depends on what is the property being used for, as to whether it's exempt as of January 1st. January 1st is that all-important date. And then I've got a few slides here on collection of tax. And really all you need to know about property tax collection is that it's very important to pay your property taxes and not get to the point where they're trying to collect them. It can get very messy if you don't pay the property taxes when they're due. They can sell the tax. There becomes a tax lien on the property that can get sold to a third party, and so you may find yourself in a situation where there's a private party seeking to foreclose on your property because you didn't pay your property taxes, and it gets messy quick. So it's always pay your property taxes if they're due, unless you've got an exemption. And so I've outlined here some of the administrative remedies that are available if you let's say you apply for an exemption and it's denied by the Board of Tax Assessors, or if you get that notice of assessment in the mail each year and you think your value is too high, you have to file an appeal either from the denial of the application for exemption or from that notice of assessment. Generally it's within 30 or 45 days. Again, it can vary by county, and you're going to appeal to the Board of Equalization is the most common route of appeal. And we'll get into that a little more specifically later on as it relates to exemption applications in particular. But the thing to remember here is that if you get a notice in the mail, either a denial or an assessment notice, you may have a time clock ticking for when you can challenge that. And if you don't act within 30 or 45 days, you may be later barred from challenging it. So that's, when you get a notice like that in the mail, it's important to potentially either reach out to pro bono partnership or seek legal advice about what you should do and not miss that opportunity. And then also the other thing, the important thing is that appeals to the Board of Equalization they're not uncommon and they're not overly burdensome. It's set up to be a pretty taxpayer-friendly system in Georgia. So it's a pretty common thing for a taxpayer, including nonprofits that get denied exemptions, to go to the Board of Equalization. And again, there I would strongly encourage you to have legal help in doing that. And then if you go past the Board of Equalization, your next step in an appeal is to go to Superior Court, and that gets it gets much more complicated when you get to court, and you will definitely need an attorney at that point. So now the important part here is the purely public charity exception from Georgia property tax. And so Georgia property tax, there's a number of exemptions from property tax. Most are in the Georgia, they're either set out in the Georgia Constitution itself or in the Georgia Code of the statutes of Georgia. And most of the property tax exemptions are based on how the property is used. And there are some exemptions based solely on who owns the property. Generally, that's government property. It doesn't matter as much what they do with it. But the other exemptions are primarily based on how the property is used. And we'll cover that in more detail here. So just some examples that potentially apply. And you might find some taxpayers some property uses may qualify for more than one exemption. And that's okay. You would just go in and say, I think I qualify for this exemption and that exemption. For example, there's a specific exemption for religious organizations, churches, that type of thing, for educational institutions, literary societies, all kinds of specific exemptions for particular types of taxpayers. And so if you fall within one of those kind of very specific exemptions, it's easier to get that exemption than if you're kind of the catch-all category for nonprofits that don't otherwise fall into a specific category, is that purely public charity exemption. And so that's why we're focused on that one. If that one is very broadly applicable to nonprofits, but it's important to keep in mind that there are these other specific exemptions that you may qualify for. So when it comes to exemptions, all property in Georgia, the way the Georgia law is set up, all property is deemed to be taxable unless the taxpayer can prove that it's exempt. And so the taxpayer has the burden of proving that it's eligible for an exemption. And so I think the important thing to take away from that is that you have to be proactive about if you think you might have a property that qualifies for an exemption. It's important to be proactive, and it's your burden to come forward to the taxing authority and prove that you qualify for the exemption, to give them all the documentation, to explain to them, file the application. I think some taxpayers sort of think, of course my property is exempt. I'm a charity, of course it's exempt, and I'll, if anybody ever comes and asks, I'll just tell them that I'm a charity. But it doesn't quite work that way. You do have the burden, and you may find yourself subject to tax if you don't sort of be proactive about taking steps to secure that exemption. And so this purely public charity exemption, this is the broad category of exemption. What do you need to do to qualify for it? First, you have to be a purely public charity, and we'll go into detail about what that is. And you have to also not use the property to produce income. There's some really important exceptions to that rule, but that's the general rule would be that you can't use the property to produce income. You can't open a storefront and sell stuff off the property. Again, with some of the exceptions we'll talk about here in a minute. So what is a purely public charity? It's not automatically, it's not tied to sort of your federal income tax exemption, the 501c3 status. Just because you have an exemption letter from the IRS does not mean that your property is exempt from property tax in Georgia. And that's different than some other states. Some other states have sort of an automatic exemption that ties off the federal income tax exemption. But Georgia's does not work that way. It's certainly relevant that you have 501c3 status, for federal income tax. That's a good factor in your favor, but that's not a requirement. It doesn't mean that your property is exempt automatically. And again, this exemption has been around probably 125 years. It started, in the mid-1800s, and the only thing that Georgia statutes tell us is that purely public charities are exempt. And so case law has developed over the last 100 years to kind of explore what that is. And so we'll go through some of that to figure out what that means, what Georgia courts have told us that means. And so the test that Georgia courts have come up with to determine whether you qualify for this exemption, we call it the York-Rite test. It's from a 1991 Georgia Supreme Court case that really kind of clarified what the test was. And so there's three pieces, three elements you have to meet to qualify for the exemption. And so the owner of the property, so it kind of looks at three things: who's the owner, who's benefiting from the services that they provide, and how's the property being used. And so the owner has to be devoted entirely to charitable pursuits. The charitable pursuits have to benefit the public. And then the use of the property has to be exclusively devoted to those charitable pursuits. And so each of these, there's a number of requirements under each of these three elements, and we'll kind of go through what those are. But you have to meet all three of those requirements for your property to be exempt. And that's whether it's real property or personal property. And so first, this is the element that looks at who the owner is. The owner has to be devoted entirely to charitable pursuits. And so, the courts over the years have tried to figure out what a charity is and how to define that. It's really broadly defined in Georgia. So and this is really probably the easiest element of the test to meet. If your purpose is to help others and not instead of to make money, you will generally qualify under this element. The courts aren't trying to second guess what charity is and what charity is not. So it's pretty easy to meet that test. And so that second requirement you have to meet is that the charitable pursuits have to benefit the public. And so, there's been a lot of questions over the years about if your service is available to whoever walks through the door, then that's you're going to qualify. You're providing services to the public. But if you limit your services to a particular group of people, and you have some qualification requirements for who you will help, who your charity will help, then there's been questions over the year about whether that's really providing benefits to the public or just some selected subset of the public. But the courts they've interpreted this provision broadly. This one is generally not, it's not that hard to meet this one. There's been cases, one of the cases I have in the slides there is the Central Board on Care of Jewish Aged, Inc. case. And in that case, it was a retirement home that only allowed people of the Jewish faith over the age of 65 to come into the home. And so the court said, well, that's okay. As long as you provide services to anyone within the group you designate as who you want to help, then you're okay. And so they would take anyone that met those requirements. And so that's a fairly relaxed standard to meet. And so the third and most important piece, and this is where a lot of the controversy around this exemption happens. A lot of exemptions get denied over this particular element here. That the use of the property has to be exclusively devoted to charitable pursuits. And so they're looking at how is this property being used, and they're looking at it, as of January 1st, on January 1st of the tax year, how is this property being used? Is it being used for charitable purposes? And then again, it doesn't matter whether the owner of the property is a charity. It Doesn't matter that you have the 501c3 status. It doesn't matter if your corporate charter says that you can only do charitable things. It's only how is the property actually being used. That's what this looks at. And so there's some, there's sort of some caveats to that rule. If some property, so if you're using property, maybe you're not actually kind of dispensing public charity from this particular property, but it's maybe your administrative office that you use to help support your charity. That still will qualify as a charitable use, even if you're not providing that use to public at that location. And then again, tax exempt land, you can have, it doesn't have to all be one group of properties together. If you have a parking, if you have a charity on one side of the street and a parking lot on the other side of the street, obviously the parking lot by itself isn't being used for charitable purposes, but if it's being used to allow your clients to park there for charitable purposes, then the fact that it's across the street won't disqualify you. And so a lot of the cases that have and a lot of exemptions disputes around exemptions that occur when a charity they have a property and they use it for charitable purposes and everybody agrees that it would otherwise be exempt, but maybe on weekdays when they're not using it, they lease it out to allow a birthday party, this meeting space, or they rent some portion of it out to a third party, a non-charitable party, and so they're earning income from this property. And so when is that okay and when is it not okay? This and the really important this case is called the Nuki Phillips case. It was a Georgia Supreme Court case from 2010, and this case really established the law for that particular situation. And so in the case, the case did hold that property that was being used for a charitable purpose in Athens, it was being used for sort of a local community center for musicians in the area, and they leased the space out for parties and weddings and that sort of thing occasionally. And so the issue was, did that disqualify them from the exemption? And the court said it didn't, because the primary purpose of the property was still charitable use. The primary purpose of this property was to operate a community center and not to lease out party space. And so there becomes a question about how often does this income producing activity occur? Does it occur? Is it an occasional activity? Is it something? The more it happens, the more it starts looking like the primary purpose, and it may not be exempt anymore. But if it's just occasional use, and of course all the income any income that gets earned has to go back to the charitable purpose. It can't benefit anyone individually or a private individual. It has to go back into the charity. But again, as long as that, it's really a primary purpose test. If you're doing non-charitable activities that generate income, the court's going to look at whether the primary purpose of the property remains devoted to charitable uses or whether it's become devoted to non-charitable use. And so, but the court did clarify that if you're providing services, and this came out of a Georgia law change in 2007, where the legislature clarified this to some degree, that if you use the property for charitable purposes and that generates income, for example, you're not leasing it to a wedding party. That's obviously non-charitable. But if you're using the property for charitable purposes, let's say a Goodwill store, for example, they're earning income from that, from operating the Goodwill store. They're selling goods for retail, but the court says as long as that furthers your charitable purpose, even if that is the primary purpose of the property, that if your income producing activity is charitable in and of itself, then you can still qualify for the exemption. Is there a question?
What if you leased a part of your property to a third party, say maybe it's the corner of the building, to have a coffee shop that's unrelated to you, but most of the building is used for charitable purposes?
Sure. So the question is, if you have a building that's used for charitable purposes and then you sublease out a piece of it for non-charitable purposes, like a coffee shop, does that disqualify the entire property? And that, it could really depend. When you sublease a piece of a building, what might happen is that the tax assessor may come in and say, well, this piece of the property, we're going to still let you be exempt, but we're going to carve this piece out into a new parcel number, and we're going to tax that. And it can vary by county, but I've seen that happen before, where property is split, mixed use. Or you could argue that the primary purpose of your property is still to generate, still for charitable purposes, and that this is just one small piece of the property. Obviously, the larger that coffee shop gets compared to your other space, the less likely you are to get an exemption on the property. But I would say a lot of counties will probably split that out. But just because that space at a coffee shop is no longer, it's not used on Tuesdays for charitable purposes and on Wednesdays for non-charitable. If you have a meeting hall and that gets leased out occasionally for parties, then it's being used for both purposes, and again, you're looking at the primary purpose to determine the exemption. So here I've got two recent cases from the Georgia Court of Appeals from last year. Just kind of highlights some of where this charitable and non-charitable uses. The first case there was you had a religious nonprofit that was leasing the property to another religious nonprofit. So you had there was a disconnect between the owner of the property and who was using the property. The owner wasn't using the property, but the court said that's okay as long as all the elements are met here. The owner is charitable, the use is charitable, the fact that those are two different parties is okay. On the other hand, there was another case where a church had a parking lot across the street, and it was sort of an overflow parking lot. It was used during the week. It was rented to a third party and used for kind of commercial parking. But then I believe there was on the weekend, on Sundays, they could use it for a certain amount of spaces for overflow parking for the church. And so again, the court looked back at that primary purpose test, and they said, well, look, this property, the primary purpose of this property is now for non-charitable purposes because you've only got 1 day of charitable use and 6 days of non-charitable use, is essentially what they said. So they ruled that the parking lot was taxable. And so one scenario that comes up somewhat frequently is when a charitable organization buys vacant property or buys property with a rundown building that they've raised enough money to buy the land, but they haven't raised enough money yet to go develop it or build the building they want to build on it. And so they have this land sitting there for a number of years while they raise more money to get it going. And so is the fact that land is owned by the 501c3, does that make it exempt? Or when is vacant land, when can it be exempt? And so for a long time, I think a lot of Georgia tax practitioners would have told you that as long as you bought the property and you committed it to exempt use, maybe you got the zoning changed, or you had an architect draw up plans for what should happen in the future, and you're going to build a community center or a church or some other clearly not-for-profit use on the property in the future, that would be enough to qualify for the exemption. But a recent case from 2012 called that into question a little bit. I think the rule still should be that as long as you've dedicated it to the exempt use, that it should be exempt. I know some county assessors would disagree with that. The case from 2012 was a case where you had everyone agreed it was a not-for-profit organization. They bought a building that had some rundown apartments, and they were going to renovate the apartments to provide low-income housing. And the tax assessor agreed that it would be a charitable pursuit once it was up and running. But they said the charity, while you're in this 2-year construction phase, you're not actually providing any charitable services. It can't be used. People can't come on the property and live there. And the taxpayer said, well, we've dedicated it. Clearly, it's going to be used for a charitable purpose. It should be exempt in the meantime. And the court ruled against the taxpayer there and said that property wasn't exempt during construction and until they were actually using the property for the charitable purpose. And so, one thing to remember about that case is, though, that the facts were a little unique. It was the property couldn't be used, because it was under construction, and the service was providing housing. The property could not be used, just kind of as a factual matter, before it was, before it passed code and construction was done. A lot of other situations, there may be some use during construction. For example, if a church is being built or renovated, the congregation may hold a prayer ceremony on the land, to dedicate the church, or they may have meetings at the property to talk about it, or to hold some sort of religious ceremony. And in that case, I have seen land granted exemptions where it's being held for future use, and there's some use of the property for that exempt purpose, even if it is just a quarterly meeting, a quarterly religious ceremony on the property. And so there's an open question in Georgia, a lot of gray area in Georgia around this particular issue. And so applications for exemption. This is I want to talk about, kind of shift from some of the theoretical, kind of how do you qualify, who can qualify, to let's say you think you qualify. How do I go about getting this exemption now? And so this is you would apply at the county board of tax assessors, and you generally want to apply for the 2014 tax year, for example, that you're looking at what the property was used for as of January 1, 2014. You're going to get an assessment notice for 2014 sometime around June or around there, June or July. And then you're going to get a tax bill for the 2014 tax year in October. And so as you're thinking about when to apply for this, really the earlier the better. But most applications go in sometime, in the first 3 months of the year, to give the tax assessor time to think about that application and potentially grant it before the assessment notices go out, before you have to pay the tax. Because if the assessment hasn't been granted by the time the tax bill comes out, you will have to pay a portion of, at least 85% of the tax, while that application is pending. And if it's ultimately granted, you'll likely be given a refund of the taxes. But the earlier you can get this application in, the better. And the application usually takes the form of a letter to the Board of Tax Assessors for the county where the property is located. And some counties have a form that you use. Fulton County has a pretty lengthy exempt property questionnaire. It's available on their website, and it goes through all these questions about what the property is used for, who owns it. It asks for all sorts of documentation, and so you can fill that out and submit it. Usually people will include a cover letter, just kind of providing a narrative explanation about what their organization is and why they should be exempt. And this is, again, applications. I would encourage you to get help from an attorney in preparing that application. There's some pitfalls in some of the questions. If you answer a certain question that you may not fully appreciate what the consequences of that answer are and not think about how that question should be answered, it can kind of trip you up in the application process. And you may ultimately get the exemption, but it might take a lot more effort than it otherwise would. And again, that exemption application is usually by the time it's done, it's a pretty thick packet of information. It's not just a filling out a form. You'll want to include also, any documentation that you can think of to support your claim. Because again, remember, you're the taxpayer. As a taxpayer, you have the burden of proving that you're eligible for the exemption. And so you want to include, your articles of incorporation that show you're created for a charitable purpose. You want to include your IRS 501c3 certification letter. If you have a similar letter from Georgia for income tax purposes, you want to include that. You want to, include maybe printouts from your website or brochures you may have talking about what type of organization you are and what you do, all the great things you do for people. And so you want to include as much detail about all of that stuff as possible on the front end in that exemption application. And again, the more documentation you can provide, the better, because if you can convince them on the front end that the property should be exempt, if you can convince the Board of Tax Assessors when they review it on the front end that they should grant this exemption application, it's a much easier process than if you submit an incomplete application or one that doesn't have a lot of documentation, just a questionnaire. What will happen a lot of times is that if it's not complete, a number of counties, instead of calling, you might think that they would call you and ask you, okay, can you send me this or that? Often what happens is they'll just look at the application as it comes in, decide what they think. If there's not enough documentation, they'll just deny it. And so you're in a situation then where you have to appeal to the Board of Equalization. It complicates the process. So again, I can't emphasize enough how important it is to get that right on the front end. So what happens if you put together this great application, you send it in, and the Board of Tax Assessors denies it? Usually you'll get that in the form of a letter from the Board of Tax Assessors, and it'll say, thank you for your application for exemption. Your application is denied. If you get that letter, that's when it's important. You may be under a time frame at that point to appeal. It might be a 30-day time frame. And so it's important to remember, reach out to the Borough Partnership or consultant attorney to help you get that appeal perfected, and so you don't miss an opportunity there. You would appeal if you think you should get the exemption and they denied it. You would file an appeal to the Board of Equalization. And most counties, there's a statewide form for appeals to the Board of Equalization, and most counties have their own version of it available on their website. You can also get it at the Department of Revenues, Georgia Department of Revenues website. And you would appeal to the Board of Equalization. It's a one-page form. You'll want to include some letter or cover letter or some explanation about why you're appealing. And they'll ask for what your grounds for appeal are. And there's a checkbox on the form for denial of an exemption application. And so you may have other grounds for appeal as well. There may be valuation, there may be uniformity, and you may want to check those. If you have those grounds, you want to check those as well. But that then goes, the appeal first, even though you've appealed to the Board of Equalization, it's a little unintuitive about how the appeals process works. It first goes to the Board of Tax Assessors, who just denied your application. It goes to them first, and they get to rethink whether they want to give you the re-give you the exemption. Obviously, if they've just denied it, it's unlikely it's going to be a different outcome the second time. But that will give you an opportunity. If you feel like you didn't give enough information on the front end, then you kind of get a second bite at the apple to contact the Board of Tax Assessors before they deny you again, and say, why did you deny me? What do I need to show you to show that I'm exempt? And so you can oftentimes work it out with the Board of Tax Assessors without having to go to the Board of Equalization. But again, you have to file that appeal first to get there. But that is the way a lot of exemption applications get granted. A denial comes in the mail, you file an appeal, and then you have a conversation with the Board of Tax Assessors. You provide them what they need to get comfortable with that exemption. And they may want to come out and do a site visit of the property, do some other things. So if you do that and you can't convince them, they say, well, we've seen all this, we just think you don't qualify. They'll tell you why. Then the appeal will get referred over to the Board of Equalization, and then it'll be typically the process takes, it varies a lot by county, but it could take 6 months to 12 months from the time you file your appeal to when it gets denied by the Board of Tax Assessors and then goes to the Board of Equalization. It'll get set for a hearing, and the Board of Equalization, it'll be a 3-member panel of really, it's just it's not a judicial court. It's not very formal. There's no rules of evidence. You just go in and you present your case to 3 people who are generally Board of Equalization members, are retired people that have some interest in probably helping out with the property tax system. They're just regular old people, not specialized. They go through training, but they're not specialized at all. So you really just you have an opportunity to go in and present your case to the board, tell them why you should be exempt. You'll want to, again, documentation is key as with the initial application. You may want to bring in people with you from your organization that can talk about what your organization does and how they help people, what the property is being used for. You might want to bring in pictures of the property. So then this is one of those phases where, again, it really helps to get an attorney involved that can go in and handle that case for you at the Board of Equalization. And so what hopefully happens is the Board of Equalization, the Board of Tax Assessors will also be there, and they will present their case as to why you think or why they think you don't qualify. So you'll both have an opportunity to present. The Board of Equalization will then rule while you have the opportunity to sit there while they deliberate, which is always an interesting process. To sit there while they deliberate and decide whether your property should be exempt. They'll decide while you're sitting there. It's a quick decision turnaround time. Hopefully they grant you the exemption. If they do, you're good to go. If not, you'll then need to consider whether to appeal. And again, you have this a time clock on what you do here. It's 30 days usually. Whether you want to go on to Superior Court. And again, you'll really need an attorney if you take it beyond the Board of Equalization. And so another thing with exemptions applications, it is a cumbersome process to some degree to get all this stuff together and get your exemption done. But once you get it done for the first year, it should continue indefinitely. You don't have to reapply every year to get your exemption or to maintain the exemption. It should just continue indefinitely. Obviously, if there's a change in the way the property is used, or if the tax assessors do revisit these properties, every few years probably, or if there's some construction done on the property, they may come revisit it. And if they think the use has changed, then you may get an assessment notice in the mail saying that your property is no longer exempt. So, but usually that doesn't, as long as the property is being used for the same purpose, once you get that in place, it'll usually continue more or less indefinitely. So it's burdensome, but it's only a one-time. For the most part, you don't have to keep doing it. And so that's property tax exemptions for nonprofits in Georgia, and I want to give people an opportunity to ask any questions they may have. If you haven't already, but we'll just give people a few minutes to ask any questions before we wrap up. Okay, well, I think no more questions. So thank you for your attention, and I hope you enjoyed this.